yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States and the state of Tennessee and this Honorable Court. Be seated.
I'm about to mess up something. I'll try again. Good morning.
Good morning.
Before we call the first case, I'll now do what I kind of planned on. Some of you may know Judge Susanna, who is the chief judge for this court and was on the court for 20, I guess, I'm not sure now how many, but over probably 24 years. Retired in 2016, died this weekend. And so we miss him. We miss him being on the court, and his portrait hangs back there. But those of you who knew Judge Susanna know that he was a lifelong Notre Dame graduate and serious fan. And it's appropriate that this went off on me wrongly, because there were times in here when he would have his phone, which he always pretty much kept on because of his wheelchair and the need to have it. But his ringtone was the Notre Dame fight song. And there were times where it would ring in here and it would play the Notre Dame fight song. And we accused him that that was no accident. People called him. So, kind of in memory of Judge Susanna and in honor of him. Three of us miss him greatly, and we appreciate your indulgence for letting us do that. There's some benefits to it. Now, if I can get the phone off of you. Yeah, we've concluded the concert. Call the first case, please.
Teresa Fletcher Kidd versus Bernice Lewis.
From the appellant.
I'd like to reserve 5 minutes for rebuttal.
That would be fine.
I'm Art Fowler from the Washington County Bar. Good morning. I too was saddened to hear about Judge Susanna. This case involves a perennial dispute between a wife, widow, and children by former marriage. I think you all are pretty familiar with it. I represent Bernice. Bernice Lewis was Charlie Lewis's wife. The appellees, the plaintiffs, or Charlie's 3 children who were born with another mother. Charlie got divorced, and then he later married Bernice. But the 2 issues in this case that we raise is first the statute of limitations. The facts in this case, it's a conversion lawsuit, statute of limitations is 3 years. All of this occurred in 2009. In 2017, the lawsuit, or Charlie died in 2019, the lawsuit was filed, 10 years. August 2009, the brother of Charlie, Don, and they were close. They worked together. But Don withdrew $300,000 from Bernice and Charlie's joint bank account, which had a right of survivorship, and deposited that money into an account in Charlie's name with only the plaintiff children listed as beneficiaries. In September of 2009, Charlie discovers what Don did, and as a trial court noted, Don's actions of taking control of Charlie's money greatly upset him. So on October the 5th, the trial court noted it was a special day, an important day it was in this case. On October the 5th, Charlie revoked Don's power of attorney, and also on that same day, Don went to the bank, got copies of the account statements, and he showed them to the children, and then they went to see a lawyer. Now, the bank statements, I think, are significant, and they are on addendum 1 in our, in Ms. Bernice, in Ms. Lewis's brief. The 2 bank statements that Don got were dated, the first one was dated August the 29th, 2009, and it showed that this account it was the name of Charles R. Lewis, P.O.D., with an address that is the brother's address. The second bank statement, which is also on addendum 1, second page, was dated September 29. Again, October the 5th is when Don goes to the bank. So Don got these 2 bank statements. The second bank statement is significant in the sense that on September 29, 2009, the court found Don knew that Charlie had changed the address for the account. But also, that account shows it now the name of Charles Lewis and Bernice Lewis, P.O.D. So an examination of these bank records would show that Don knew, and because he told the children knew on October 5, 2009, that they had been wronged. They were, under the Red Wing case, they had constructive notice that they'd been wrong.
And counsel, the second account statement showed POD to Bernice.
Excuse me?
The second account statement showed POD to Bernice, but the first one didn't?
No, it did not.
Okay.
So when you look at the first statement, which is in August, after Don changed the account, it shows it was just Charlie Lewis. But then when you look at the next bank statement, it shows that it was Charlie and Bernice. And he had those records. And those people, the plaintiffs were then put on constructive notice, as Red Wing discussed, that they potentially had been wronged. After that, it's interesting, they all go, Charlie and Don and the children go and talk to a lawyer. And after they talk to the lawyer, the testimony is, they decided to just let it play out. And so the next 10 years, they let it play out. And then they filed their lawsuit. And the testimony in this case would be that Bernice testified that she had 15 witnesses who could have supported her position. 12 of them were deceased. The banker, the financial advisor, and the lawyer, the trial judge found that their memory was so vague that he didn't give it any credence. So the 10 years greatly impacted Bernice's defense in this case. The other issue I want to address with the court is the ineffective power of attorney. In 2000, Charlie gave Don a power of attorney, but it was what we call a springing power of attorney. It was ineffective until Charlie became incompetent. If you look at Addendum 2, the first page says that I appoint Don as my attorney in fact, subject to incapacity requirements set forth hereinafter. And if you go to the second page on the left, there's a little tick mark. And it says, this power of attorney shall become effective upon the disability or incapacity of the principal, Charlie, and remain effective. The principal's disability or incapacity is proven and is conclusive on all persons by a writing signed by the principal's usual attending physician, signed for at least 60 days before. Now, clearly it meant that there had to be that Don or Charlie had to be disabled, and that there had to be a companion document from the doctor saying he was disabled. But in this case, the testimony is that there was no companion document. If you will look at volume 3, page 298 and 299 in the testimony, Carl McInturf, the lawyer who drew this power of attorney, testified clearly that it is ineffective, open quotes, without having the companion document from the doctor, close quote. Don knew that. Don went to the attorney, Mr. McInturf. Don asked the attorney to prepare the physician statement, which Mr. McInturf did. Don took that physician statement to the primary care doctor's office, and they didn't sign it. It was not signed. Now, that occurred after Don was already using this ineffective power of attorney.
Counsel, your opponent says, look, that provision you talked about there about the doctor signing is just a way to say, here it is, it's conclusive, the presumption is now conclusive, but it's not the only way. That you don't have to have that to prove incompetence. It's just a way of proving it so it's beyond question.
The author, I love English literature, where they'd say, well, tell me what Chaucer said. What did Chaucer mean? I didn't have a clue what Chaucer meant. But in this case, we brought in the person who drafted that power of attorney, Carl McInturf. He says you need to have that. But let's assume, Your Honor, that you're correct. There is no evidence in this record that Charlie Lewis was incompetent or incapacitated at the time that power of attorney was used. He just sold a $500,000 piece of property where he signed the deed and the notary says he was competent. He had just revoked the power, shortly thereafter, he revoked the power of attorney Don gave him. Carl McInturf, the attorney, said he was competent when he did that. That same day, he did a health care power of attorney, October 5, where he appointed Bernice as his health care power of attorney, and the lawyer said he was competent when he did that. Interestingly, he did not appoint anybody power of attorney over his financial matters. Bernice, if she were controlling him using undue influence, you would have thought that Charlie would have wanted Bernice to have a power of attorney for financial purposes. That was not done. So clearly, an ineffective power of attorney was used to withdraw $300,000 from a joint account with tenants by the entirety. Under the Fletcher case, only a husband or a wife can destroy the entirety status of an account. In this case, Don had no power, authority, or right to withdraw this money.
You used your time, counsel. You have your time for rebuttal.
Thank you.
Thank you. We're in the appellate.
Good morning. I'm David Robbins of the Washington County Bar. I have with me my associate Barbara Malone, also of the Washington County Bar. And we thank you for your honor and remembrance of Justice Susano this morning. Appreciate him. One of the first justices I appeared in front of in 2009. I think you two were on the panel at that time too. So it was good to have that. I appreciate that. Without going too much into the facts as they've been recited by Mr. Fowler, this appeal is very much based on factual issues and not so much on issues of law.
Counselor, would you home in for me just exactly what did Bernice do as far as her overreaching and controlling child of her husband?
If we go all the way back, you know, and there was detailed testimony on this at trial. We had an expert witness who reviewed the medical records, who goes all the way back to Bernice having to look over his shoulder to write checks. When we fast forward up to the time of the complained of incident, we see suspicious circumstances start to arise. August 22nd of 2009, there's a late night phone call in which Dawn Lewis indicates that Bernice Lewis is berating her husband over the existence of a will and being able to locate a will, and that they're down in the basement digging in his safe in the middle of the night. There's testimony from Teresa Fletcher, the decedent's daughter, from early October, where he calls her. He's completely despondent. She describes him as distraught, among other things. We see that Bernice Lewis at this point has Charles Lewis revoke this power of attorney. She's now at the bank with him. She is meeting with the banker to set up an annuity that benefits her and no longer the children. This is in direct contradiction to the decedent's last will and testament. The only thing that the spouse was provided for in the last will and testament was the right to live in the house during her lifetime. And everything else, the entire residue, aside from a couple very small specific bequests to some grandchildren, would have gone to the 3 children. So there's this really overwhelming change in what Charles Lewis is trying to do, combined with his weakened mental capacity, as well documented by VA physicians, neurologists, testimony from his brother who had a close relationship with him for decades. In fact, there's testimony for approximately a month around the time that all these changes were made that he had cut off contact with his brother, that there was no contact at that point. The suspicious circumstances combined with the total 180 and what was going to happen to Charles Lewis's estate, I believe underscores and necessitates the finding of undue influence that the trial court made. And I really don't believe that there's anything in the record that contradicts that.
Counsel, I'm sorry.
Sure.
On the annuity, when was it purchased?
The annuity was purchased November 16th of 2009.
And who did the payments go to?
The payments went to Bernice Lewis.
To who else? They didn't go to Charles Lewis?
They may have gone to Charles Lewis during his lifetime. I apologize. The payable on death beneficiary of that was Bernice Lewis.
And how long before he died? When did he die?
He died February 22nd of 2017.
So for 8 years, he received the annuity payments.
That's correct.
Is that a problem for you. I mean,
Oh, not a problem for me.
I understand it's not a problem for you. I'm afraid that's a problem for your case. I mean, when you argue about that, she used its undue influence to receive this, but for 8 years, he receives the benefits.
And she also received the benefit, too.
I understand. The benefits went into their account, I think.
At this point, he's incapacitated, and she has control over these funds. The other issue, too, if we look to the testimony of Don Lewis in this case, Don Lewis indicated that the purpose in setting up the account that they did was that it was a CD. Charles Lewis would often use the term coffee and gas money. He just wanted to get some coffee and gas money and leave something to the girls. And that was what was produced in the testimony at trial. The idea that he would then receive payments that severely depleted the principal of the CD, and then this was a certificate of deposit, if I recall correctly, it really flies in the face of his goal to preserve the principal wealth for his children, but while still drawing some benefit during his lifetime. I don't think he intended to draw that much of a benefit. And, you know, we see what a benefit that was to Bernice Lewis during that period of time.
A lot of things happened here. I mean, he sold the property.
Correct.
Was he competent then?
That's a good question. And that was never raised or addressed at the trial level.
When he told, and I'm going to use their first names because otherwise I can't tell straight. When he told Don, you know, I want to leave money to the children, was he competent then?
Yeah, that's a good question. The court
Well,
believes
I'm
that he
trying to
was.
figure out why he was competent to do, I mean, property sold, nobody complains, including Don Lewis. Don Lewis said, he told me that he wanted to leave this money to the children. That's why I moved it out of the account that it was put in. It was in Charlie and Bernice's name. And so he was competent then when he told me that. But now when he comes back from Alaska, he's no longer competent, and so when he changes it into an account for him and Bernice, and he buys the annuity with it, then he's not competent.
And I understand that lucidity is fluid, and I understand there are periods of time where somebody may be able to complete certain transactions. I realize that other transactions may be more difficult for somebody with severe cognitive decline. And the court was able to examine that evidence, was able to hear from those witnesses, and made the determination.
In light of that, when did Don get the account statements that showed that it was the name of Charlie and Bernice?
There was no evidence adduced at trial as to when those account statements were received by Don Lewis. The other issue we have, Your Honor,
There was no evidence that did he admit getting them?
there was no evidence they'd been received. Yes, we have that in the record, but there was no testimony that he had received them. There was nothing to that effect, to my recollection, in my review of the record. What I will say as well is that Don Lewis is not a party to the action. The part is to the action.
I understand. So you're saying there's no proof presented that he went to the bank, got those two account statements, saw what Charlie had done, told one of the children, one of the daughters, I don't remember, and they went to see a lawyer?
My understanding was that he had gone to check on the account and was told that he was no longer the attorney in fact. Based upon the phone call and based upon the visit to Charles Lewis's house in early October of 2009, the parties consulted with an attorney with the intent to seek a conservatorship over Mr. Lewis. That stopped, and the testimony at trial would show that that stopped because the appellee's mother had died at that point, and it was a very emotionally upsetting event, not just for Charlie Lewis, but also for the daughters, and they decided at that point that it would be very harmful to try and push litigation as to his competency at that point.
For another 8 years.
That's my understanding, Your Honor.
Okay. All right. We'll check.
With respect to the statute of limitation, the court found that the claim of conversion was told as the change of beneficiaries was beyond what was discoverable. And we've heard the argument that Don Lewis received a copy of the statement. There's nothing in the record to suggest that the defendants were put on notice, first off, of the change, but secondly, that the change was so drastic. Attachment 2 shows Charlie and Bernice Lewis, and it has POD. It doesn't say who the POD is. There could be a reasonable belief that they were still the designees under that account. The children also were not the attorneys, in fact, as Don Lewis was, and they never did have access to the financial information. The only information that they could receive would have been voluntary from Don Lewis, and that was completely gratuitous, and that Don Lewis had no fiduciary relationship with the children, other than the familial relationship of being their uncle. There's nothing in the record that controverts this, and the statute of limitations, as far as the court had found, and I would continue to argue, was told until at least Charles Lewis's death, when these things could have been discovered by the plaintiffs, and that was February 22nd of 2017. The complaint was filed within 3 years after that, and would have been a valid complaint, not subject to the statute of limitations, but told. So with regard to the second question, this is one that we've gone around so much with, but I want to walk back through one more time. The power of attorney. So this issue is raised at trial, and the court found that Charles Lewis was incapacitated. This is a finding of fact that the trial court made based upon the testimony and evidence before it. And there doesn't appear to be anything in the record with greater convincing effect. The power of attorney has language in it which would make, as Justice McClary pointed out, would be conclusive, but is not necessarily required. There is no required finding that there be a doctor's statement. The only person who opined to that effect was the drafting attorney, and that was merely a statement of opinion on his part. There's no definition of incapacity in the document. Being that there's no definition of incapacity, my argument would be that we look at what the law says regarding incapacity. We looked at conservatorship of groves. It says the legal status that occurs when a person's autonomy becomes either partially or totally impaired. A person lacks the ability to be autonomous, to exercise free will, when he or she lacks the ability to absorb information, to understand its implications, to correctly perceive the environment, or to understand the relationship between his or her desires and actions. With regard to the ability to correctly perceive their environment, Bernice Lewis has testified. These are in her own words. They're descriptions of her having to supervise the land transactions, for her having to supervise the bill paying. She said at one point he would have signed some papers that would have cost them a lot of money. There's evidence that he was having difficulty with names, dates, processing Bible studies. In 2009, at the time of these transactions, he even asked why he divorced the children's mother. He didn't have the ability to grasp, absorb, and understand the implications of even that information at that time. There were descriptions of him becoming frequently disoriented, confused, and specifically Bernice, who was his wife and caregiver, there were times that he did not know who she was in 2009. With regard to the third issue that had been raised in the brief, and that was not raised during the appellant's argument, but I would like to address it, there is language in the will indicating that the estate would be responsible for taxes, maintenance, and insurance on the decedent's real property. The appellant had filed a countersuit requesting that those fees be paid by the children of the decedent, Charlie Lewis. There is no legal obligation for the children to pay that. There is no specified contingent language under the will that they would inherit the property if they paid those things. The record shows that the estate is insolvent. Therefore, the trial court found that the claim failed. We would argue the same, that despite the amount and despite whatever reason the appellant feels entitled to those fees, there's no basis at law. Thank you for your time.
Thank you, counsel. We'll get to the appellant rebuttal.
Thank you, Your Honor. I detected an interest in when did Don know that the account had been changed. It is clear this happened 10, 12 years ago, but contemporaneously with this happening, Don made very copious notes, and they were introduced into evidence. They're in the trial exhibit. We had 2 notebooks, and so in volume 8 you have I call it TN, trial exhibit notebook. It's volume 2, but it's at the end of the initial exhibits. But if you look at the pages there, Don's notes are page 47 through 85. At page 72, Don wrote that he got copies of Charlie's bank accounts. So if there is evidence in the record in October 5, he got those records. The next thing I want to talk about is Charlie's mental state during that time. I would refer the court to volume 7, exhibits pages 731 through 760. Those are the medical records from the VA. But the most important one occurred. It was a note on November the 18th, 2009, volume 7, page 731. The doctor noted that Charlie had received a new medication from neurology and was doing much better, went on a trip to Alaska and had a great trip. No major problems. So that was in 2000, as November the 18th. The Alaska trip, the court found that Don did all of this magnanimously for Charlie while Charlie was in Alaska. That was wrong. August the 21st, Don transferred the $300,000 to the account for the children. Don and Bernice did not leave for their trip to Alaska until August the 28th. It's in the record. It raises an interesting question. Don and Charlie were together almost daily from the time that money was deposited into their joint account until the day Don took the money out of that joint account. They were together daily. Yet Don did not know that Charlie did not know that Don had gone down, used that unsprung springing power of attorney, and withdrew the $300,000 until he got back from the Alaskan trip. As the court said, when he found that out, he was upset. Why didn't Don, on August the 21st, with his brother there, take Charlie down to the bank and do what Don did? If the children felt that there was some risk they were going to lose their inheritance, why didn't the children go talk to Daddy, to Charlie? Why did they do all this stuff behind Charlie's back? And the answer is simple. As Miss Fletcher, the daughter, testified, we were doing what we assumed Daddy wanted. Well, I don't think that's the case here. I think this is what Don, their uncle, and the 3 children wanted. They wanted their inheritance, and they have not proven it. And if, in fact, Don or Charlie was incapacitated, and he had dementia. He had the onset of dementia, but it was moderate, mild. But if he had dementia and Bernice somehow overreached, it happened after Don took the money out of that joint account. Don's taking the money out of that joint account did not destroy its tenancy by the entirety status. Only a spouse can destroy that status. So when Don improperly took out that money with an effective power of attorney, if the court finds that Bernice did something wrong after that and overreached, then what should the court do? The court should then cancel that transaction and redeposit the money into the joint account with right of survivorship. Bernice did not convert anything because it was her own money. For conversion, you got to take somebody else's property. That money was Bernice's money, and it's hers no matter how you slice or dice this. And I would ask the court to overrule the chancellor. He usually does a good job, but I think he was wrong in this case. And to find that that money, no matter how you examine it, belongs to Bernice, and that she should be compensated for paying the taxes and insurance on that property, which the children are going to inherit, or they're going to get it as soon as Bernice leaves, whether she dies, remarries, or just moves out. It's their property. They need to maintain it, and they need to pay for the cost of maintaining it. Thank you, Your Honor.
All right, I know your time, but let me make sure I understand. Are you saying that since this was joint account tenants by the entirety, that Charlie, even with the power, assume the power of attorney was effective for the purpose of this question, that he could not make the transfer that Don could have made? In other words, the power of attorney didn't give him the power to do what...
If that were an effective power of attorney...
I'm saying if it was.
If it was, we wouldn't be here today. Okay? That power of attorney, if it didn't have that provision about it's only good if I'm incapacitated or disabled, if it didn't have that language in there, we wouldn't be here today. But it's clear, and you pointed out, Your Honor, that Charlie was competent to sell the property. He was competent to pay off 2 loans at the property security. He was competent to buy a car. He was competent to pay the capital gains tax. He was competent to cancel that power of attorney. He was competent to have a health care power of attorney prepared for him, for Bernice. He was competent for all those things, but then the appellates want to say that somewhere in there...
Counsel, you all beyond my question.
He was incompetent. Okay. Thank you, Your Honor. Appreciate your
Of course, thanks to counsel from both sides. We appreciate your oral argument.
And I was dilatory. I didn't mention my son, Arthur Fowler III, has accompanied me down here to make sure I did okay.
It's a good thing you remembered that before.
Thank you.